So today in this session we are going to start with a very important chapter from the corporate and other laws, and the name of that chapter is Companies Incorporated Outside India. From this particular chapter compulsory a 5 marks to 6 marks questions will come, and MCQs also chance is there. Why we are starting with this chapter means, and why we need to read this chapter is, this chapter once you read, once after this we will start with FEMA. Okay, so first we'll complete the questions and answers in the foreign company, company incorporated outside India. Once that is completed, we will start with a continuous foreign exchange chapter called as FEMA. So FEMA will be coming for around 8 to 10 marks. This will be coming for 5 marks. Two chapters, FEMA and foreign company, if you read, totally put together will be for minimum 12, maximum can soar up to 15 marks. So two chapters coming for 15 marks is not a joke. So we are going to first cover those two also now. Okay, so our sequence now is, first we will cover companies incorporated outside India, that is a foreign company chapter. Once completed, we will also start with the FEMA. Everyone participating, clear? Those participating, clear? Yep. So you can see now. Companies incorporated outside India are the name of the chapter. With regard to the companies incorporated outside India, you can see I am having 40 questions with me. Okay, these all questions we have to solve. Once you solve this, then only we will get a confidence as to whatever the question that comes in exam, we will be able to tackle and solve it. Okay, let us begin. Number one, question number one. X incorporated a foreign company. So they are only saying that it is a foreign company registered in UK outside India and carrying on trading activity with the principal place of business in Chennai. Okay. Since the company did not obtain registration or make arrangements to file return, registrar having jurisdiction intends to serve a show cause notice on the foreign company as a standing counsel. Counsel means advisory person for the department. Advise the registrar on the valid service of notice. On the valid service of notice. Okay. Listen. Here, question is on what? Question is not on penalties. Question is not on how to register and file returns. It is talking about there is a foreign company which is which has started its business, incorporated in UK, place of business, principal place of business is in Chennai. Such a kind of a foreign company has to file returns or not? If they did not file, then what is the penalty? He is not asking. What he is asking, the question is, ROC wanted to issue a show cause notice. Means he wanted to ask, please show a cause why you did not file. For that he is issuing a show cause notice. He is asking in the question, if I issue a show cause notice, how to issue, on whom I should issue, is a question now. Why this question came? Listen. As per section 12, normal, the company is normal company, not a foreign company. Normal company, there is a section 12. Incorporation chapter you might have already read. Okay, the name of this section is registered office of a company. As per this section, do you know what is the provision? Every company required to have a registered office, okay, within India, and it has to maintain it all the times till winding up of a company. And what is the significance of a registered office? This is a place of communication. This is a place of communication. Means any kind of communication to be served on a company, don't issue to the director's address, don't issue to the shareholders address, issue to the company's address. Company address means what? Registered office. So ROC wanted to issue any notice, registered office. Income tax wanted to issue any notice, registered office. RD want to issue any notice, registered office. Members want to communicate, registered office. It's a corporate address of a company. Any communication to the company must be addressed to the registered office. However, this is not possible in case of a foreign company because registered office is in UK, in a foreign country. So, for example, GST provisions. Okay, for example, GST provisions within India. GST provisions are there within India. Our company main branch is in China, say for example. They don't understand our language and also our act. So you are issuing notice to the registered office in China. Is it serving your purpose? No. Therefore, one section was introduced 383, which is called as a service of notice. What this section says, in case of a foreign company, in case of what company? Foreign company, if any person wanted to, okay, send any kind of communication or any document or any notice, okay, any document, notice or any communication which is required to be served on a foreign company, you need not serve it on the registered office. It is deemed to be served properly if it is addressed to such person whose name and address have been delivered to ROC under section number 380. Sir, I did not understand. I will explain. Whenever a foreign company is formed, place of business should be in India. Incorporation may be outside India, but they should have a established place of business in India. In India, you established a place of business or not? Where? I established a place of business, say it is in Chennai. Am I clear? Chennai. So, establish a place of business in India in Chennai. Now, what they ask is, in case of a foreign company, ROC or any GST person, anyone, if they wanted to communicate with the foreign company, don't send to the RO. You do one thing. For this place of business in India, one representative will be there. He is a Indian resident. He is what resident? Indian resident, and he must be individual. And he must be individual. This individual being an Indian resident will be the representative. Okay. To start this place of business, we need to file some document. For example, if you wanted to incorporate a company, there is a procedure or not like that. To establish a place of business, there is a section called as 380. In that 380 section, we have to file certain documents with ROC to establish place of business in India. While sending the document, 7 documents we need to send. How many? 7 documents we need to send. In that 7 documents, one of the document is name and address of authorized representative. Name and address of authorized representative. Okay. So therefore, what section 383 says? Any notice or a document or a communication which is required to be served on a foreign company shall be deemed to be sufficiently served if addressed to such person whose name and address have been delivered to ROC under section number 380. Means really you need not send to the RO in UK. It is enough if you send to the authorized representative whose name has been submitted to ROC under section number 380. That's what he wanted to tell. So please everyone confirm. Those who are listening live, understood the concept clearly? Okay, see here. According to section 383 of Companies Act, any process, notice or any document which is required to be served on a foreign company shall be deemed to be sufficiently served if addressed to any person whose name and address have been delivered to the registrar under section 380. Okay. Sir, you have to send to that authorized representative. So no need to send to RO in UK. No need. Don't send to RO in UK. Send to the authorized representative who is receiving all the communications documents on behalf of foreign company in India. Okay. In India. You can put one representative, he will take. To him you need to send. Sir, how to send to him? Email or posta. You can send either by post. Okay. Or you can send by electronic mode, either post, okay, or by electronic mode. So Hence, the registrar may serve the show cause notice by the following above provisions. That's it. This is asked in 2 marks for August 2018 CA final exam, because foreign company chapter came into CA Inter last attempt. Okay, but I have 40 questions from where they came from CA final I have taken. Okay, if those questions, if you can solve any question, you can solve. And moreover, from these 40 questions, one question will come in the next attempt. Pakka. We will meet after exams again. Okay. Next, RTP May 2018. As per the provisions of Companies Act 2013, what is the status of XYZ Limited, a company incorporated in London, which has a share transfer office in Mumbai? Listen first. I will first do one thing, I will explain. After explaining, I will tell. First, what is a foreign company? Okay, this particular question is based on two sections. Section 2, class 42 and section number 386. Two sections they merged and they asked in examining in the RTP. First, what is a foreign company? Company incorporated outside India, having a place of business in India and conducts business in India. Three conditions you have to satisfy. First, it should be incorporated outside India. Means if it is incorporated within India, it is not a foreign company. Number one. Place of business must be in India. If place of business is outside India, it will not become a foreign company. Second condition. Not just establishing a place. After establishing the place, it should really conduct the business. Okay. Now, place of business can be of two types. Number one, either by itself or by agents, either physically or electronic mode. This is a foreign company. Now question arises. Sir, what is a place of business? You start a branch, you start a franchisee, you start a clerical office, you start something. Okay, some business should be going on there. Then question arises. See, a company creates its business. A company will create its business. To create a business, it requires capital. To create a business, it requires capital. So from capital only business will start. Am I clear? I repeat one more time. Whenever capital is raised, business will start. Whenever capital will raise, business will start. Listen carefully what will happen. There is a company incorporated outside India. There is a company incorporated outside India. That company established in India a share transfer office. What office? Share transfer office. Means what? They will purchase the shares. People in India will purchase the shares of that foreign company. Okay? Purchase the shares of that foreign company. I purchase the shares of that foreign company through a foreign exchange. Okay? Foreign stock exchange through I purchase the shares of a particular company. Later after some time, I wanted to sell. Later after some time, wait a minute here. Later after some time, I wanted to sell the share. I sold it. Then who will do the transfer work within India? In India, if you purchase the shares of a company, already depositories to depositories are there, NSDL, CDSL. But if you purchase the shares of a foreign company, who will do that work? One share transfer office should be there within India. Okay. So share transfer office will be established in India such that people can buy and sell the shares of a company within India and they can get it transferred through that share transfer office. Okay, I am the owner of the shares of a foreign company. I wanted to sell it. You will buy it. Okay, in your name it should be registered or not. Who will register? One share transfer office should be established within India. Okay, so the foreign depository through this company will start a share transfer office in India. Through that we will do. The moment you are doing share transfer within India, people will be coming to know about you. Okay, slowly the business for the company also will grow. Therefore, what lawmaker said is share transfer office, share registration office, both will be treated as place of business only. Buying and selling of goods and services not only is a place of business, buying and selling of shares of that company will also be treated as a business only. So therefore, establishing a share transfer office or share registration office, both are regarded as place of businesses. Who said it? That was said in 386. So 386 said that place of business includes share transfer office and share registration office also. So foreign company means a company incorporated outside India, having a place of business in India itself or agent, physically or electronic. First I done that you have to write. For this they will give some mark. Next, conduct business activity in any other manner. Next, according to section 386 of Companies Act, okay, the place of business includes share transfer or share registration office, as what I said. From the above definition, the status of XYZ Limited will be that of a foreign company as it is incorporated outside India, has a place of business in India, and it carries on business activity. Okay, so therefore, share transfer office will be treated as a place of business or not? Yes, it will be treated as a place of business. So those who are listening, please reply. Everyone understood up to here? Yes. Next one. Question number 4. X, a foreign company with a place of business in India, ceases to carry on the business in India. State the legal provision of such foreign company under the Companies Act 2013. Okay. First, read the question before we go to solution, and I am very clear about it. Please don't see the answers below. First, read the question what they are asking. Okay. That if you understand the question, then answering becomes easy. Read the question properly first. Okay, let's start. Sir, what is this question? This question is based on section 376. Section 376. Let me explain. Okay, listen. What they are asking is, there is a foreign company having a place of business in India, ceases to carry on the business in India. State the legal provision of such a foreign company under Companies Act 2013. Okay, first listen carefully. Whenever winding up happens under Companies Act, winding up is of two types: winding up of a registered company, winding up of a unregistered company. Winding up of a registered company, winding up of a unregistered company. So what is this concept? This is winding up of a unregistered company. So what do you mean by unregistered company? It is not registered under Companies Act 2013 or any previous company law. Example, there is a foreign company incorporated in UK. Incorporated in UK. There is a foreign company incorporated in UK. Okay. Now listen carefully. It is registered under Indian Companies Act, Foreign Companies Act, Foreign Companies Act. But it established a place of business in India. Place of business is not incorporation. It's only a branch. It's only a business unit. Okay. That winding up will not be under our provisions. So therefore, what they said is, whenever a foreign company wanted to close its place of business which is established in India, normal provisions of winding up completely do not apply. You should wind up that under section 376, which is discussing about winding up of unregistered companies. You should follow that provisions and then you have to wind up. According to section 376, where any body corporate incorporated outside India which has been carrying on business in India ceases to carry on the business, it may be wound up as an unregistered company under chapter 21 of Companies Act. Okay, that's it. That's a more important point. Notwithstanding means ignoring that the body corporate has been dissolved or ceased to exist as such under or by virtue of laws of the country in which it is incorporated. Means what? In the outside country, for example, in foreign, in UK the company was wound up. In UK, company are not there. Even if in the UK company is not there, automatically branch also will not close. Here branch closure in India, place of business closure in India must be as per section 376. Means even if the UK company, the main source of company is in UK, POB is in India, even then if the source itself is closed outside India, even in that case you have to follow the provisions of 376 to close the place of business in India. Next, LMP Paper Limited is a company registered in Thailand. Although it has no place of business established in India, yet it is doing online business through telemarketing in India. Explain whether it will be treated as a foreign company. Listen carefully. Company, what is a foreign company? First, you have to explain what is a foreign company. For that, only marks will come. How to present the answer? Foreign company means a company incorporated outside India which has a place of business in India, whether by itself or through an agent, physically or in electronic mode. Here, how they are carrying on? Electronic mode. Electronic mode includes telemarketing also. Electronic means does not mean only email. Electronic mode does not mean only website. Telemarketing, e-marketing, business to customer. Okay, telemarketing, television marketing, phone marketing, internet, web-based services. Any kind of electronic business will be treated as a electronic mode. So here, as per section 2 clause 42, read with companies act, etc., any, what is a foreign company? Any company or a body corporate incorporated outside India, test 1, having a place of business in India, test 2, and conducts business activity in India, test 3. First you have to write that. For that they will give you that 1 mark. Next, whether what do you mean by electronic mode? Sir, J25 key market important, they can ask at that time. Be ready, you have to write these 5 points. Okay, listen. Business to business means distributor to wholesaler, like that you may do. Online, you are not selling to customer. For example, Amazon is there. Amazon is what? Amazon is a business to customer model. In Amazon, business to business is also there. So you may do business to business, or you may do business to consumer, or you may do the data interchange, okay, or any kind of digital supply transactions. Next, this is regarding the trade. Next one is the finance. Okay, next one, finance. Accept deposits. Okay, accept deposits. Accept subscriptions in securities, either in India or from the citizens of India. Either in India or from the citizens of India. First one is what? First one is relating to the trade. Business to business, business to customer, data interchange, and digital supply transactions. Any kind. Number one. Number two, accept deposits. Accept deposits. Next, accepting the subscription in securities in India. This is the second one. Next, after that, next one is also finance. Next one is also finance. What is this? Financial settlements. Loan taken online, we are paying online with a foreign client. So web-based marketing, advisory and transactional services, database services, telemarketing, telecommuting, telemedicine, teleeducation, and information research. Anything. So telemarketing, telecommuting. Next one, telemedicine and teleeducation. Online education if you are taking from a foreign person, that will also be included. Okay, any kind of data communication services. Okay, like any other purchase or sale made through emails or by mobile devices, social media, Instagram, they will give click here and buy. So foreign person will be there, but we are buying the products from there. So cloud computing, okay, anything of any nature, all these put together we call as a electronic mode. This you have to remember, there is no other choice. These are 5 points, at least 60-70% you need to replicate in exam. So in a simple way, if you have to understand, see here. First one, business to business, business to customer, electronic data interchange. This is the first one. Simple words, at least remember this. Number two, deposits and subscriptions. Okay, deposits and subscriptions. Next, I will take legal advice, chartered accountant's advice, company secretary advice. I will take advocate's advice outside India. Okay, those are called as advisory and transactional services. Okay, next one, web-based marketing. Web-based marketing means I will use a foreign website to market my product. Okay, this I will tell financial settlements, advisory, web-based marketing. Next one, any kind of tele-related things, telemarketing, telecommuting, telemedicine, tele-education, anything, telemarketing, commuting. Next, medicine, education. Okay, next, all related data communication services. All related data communication services means if you are doing any kind of data communication services, click here in the email, you will get the product, you can pay online, like that. Anything if you are doing through emails, cloud, okay, or any data transmission, any data transmission. All these will comes under the category called as a electronic mode. Jan 25 exam, mark it important, it can come. These 5 points you have to write at that time, remember. Okay, so in this, what is the question he is asking? Telemarketing he is doing. Telemarketing is coming under this category, so therefore it is a place of business only. Okay, what place of business can be carried on either physically or through electronic mode. Electronic mode la what are included? These are all included, but mainly you need to understand one thing: server location is not important. Is it a foreign company or not is important. Sir, foreign company, sir, server is in India. No, main server is installed either in India or not. Okay, server location is not at all important, believe me, and remember that point. Everyone reply, understood up to here clearly? Next, in case a foreign company does not deliver its document to register of companies as required under 380, state the penalties. He is not asking procedure to apply under 380, he is asking what will be the penalty. For all penalties in the question bank, I kept the penalty chart, just you need to read. Okay, I will show you, just wait a minute. Penalties are to be remembered, nothing will be taught in penalties. I will do one thing then. We'll first show you the penalty normally. You remember this. After that, we see in the penalty chart also. If you do not file any document and you committed any non-filing for contravention of the provisions, directly remember the penalty. From here, it is relevant. The foreign company shall be punishable with a fine, which shall not be minimum 1 lakh, maximum 3 lakh. Next. Okay, next. And in case of continuing offense, means if you continue that further, today is the due date, you did not file, minimum 1 lakh or maximum 3 lakh fine will be there. Even after that you are continuing that particular thing. Okay, for the continuing penalty, it will be 50,000 per each day. This is on foreign company. Okay, this is on foreign company. Then what is the punishment on the officers in default? Company is an artificial person, it don't do anything on its own. Officers are also there, they also did contravention on them. On them they said that there will be imprisonment for a term up to 6 months, or fine minimum 25,000 and maximum will be 5 lakh, or sometimes even with the both. Even with the both, this is the penalties that will be imposed. But you need to remember one thing. Let me show you. Okay, see here now. Latest amendment is there. They removed the penalties and they changed. What is it? Let me explain. Punishment for contravention without prejudice to the provisions of the, if a foreign company contravenes the provisions of this chapter, foreign company shall be punishable with a fine which shall not be less than 1 lakh, 3 lakh. Continuing offense, 50,000 rupees for every day. Okay, every officer of the foreign company who is in default shall be punishable with a fine which shall not be less than 25,000, but which may extend to 5 lakh. Sir, everything is same now, sir, whatever you have written. The only thing is fine, imprisonment of 6 months they removed now. Except that everything is same. That's what the amendment. So amendment I wanted to note down. Here there is an amendment. I am marking here. Imprisonment for a term which may extend up to 6 months. This is not applicable because the amendment they removed that. Okay, so it is no more there. Imprisonment they removed, remaining all fines are there. Everything is applicable. Next, question number 5. Examine and state whether the following companies can be treated as a foreign company. A company which is incorporated outside India, employs agents in India but has no place of business in India. Okay, employs agents in India. Sir, what do you mean by employees made in India? The main point is try to understand clearly. First, foreign company means what? Foreign company means a company incorporated outside India, having a place of business in India. That place of business in India, after establishing, how we can establish place of business? Either by itself or through the agents, either physically or in electronic mode, and conducts business in any other manner. Here what they said, a company which has incorporated outside India has agents but has no place of business in India. Just appointment of an agent is not enough. First establish a place of business. That place of business may be run either by you or by a agent. Making agent will not become place of business. Place of business should be established where your agency can be there. Okay. First you have to write the definition. After that, a company incorporated outside India and have not established a place of business, it is not deemed to be a foreign company. Thus, establishing place of business is an essential ingredient in the definition. In the given case, company has not established a place of business, okay, through the employees agent, it will not be deemed to be a foreign company. See, what is a foreign company? Company incorporated outside India having place of business in India. That place of business in India can be either done by itself or by agents. So first establish POB, which will be carried on either by you or by your agents. Making agents appointment will not become POB. In POB you should appoint agents. Understood the difference between both the statements or not? Everyone reply. Understood the difference between both the statements? Next. A company incorporated outside India having shareholders who are all Indian citizens. Company incorporated outside India having shareholders who are all Indian citizens. Listen carefully. Company incorporated outside India having shareholders being Indians does not make an Indian company, does not even make a foreign company. Okay? Why? What is a foreign company? Company should be incorporated outside India. Place of business is important, not the shareholder citizenship. Understood? So, company incorporated outside India will not be deemed to be a foreign company even though all shareholders are Indian citizens unless it has a place of business in India. That's it. A company incorporated, see, this was asked in 8 marks, CA final, November 18. A company incorporated in India, but all shareholders are foreigners. Nonsense. Company incorporated in India becomes Indian company, becomes an Indian company. Whether or not shareholders are Indians or foreigners, that is none of our business. The main point is company once incorporated within India, we can never call it as a foreign company. It will be treated as a Indian company only. Company incorporated in India, but all shareholder will be deemed to be an Indian company. It is not incorporated outside India. It has no place of business, so it's not a foreign company. Next, a company which has no place of business established in India, it is doing online business through telemarketing. Yes, this is a foreign company because place of business need not be physical. It may be electronic. Electronic means not always on a website. It can be even on telemarketing. Just all the 5 points, whatever you remember, write down, and will be treated as a foreign company. For that, 8 marks. Question number 6. Question number 6. Next. Kingai Hudang Industrial Company Limited, incorporated in China, established a place of business at Mumbai. Place of business at Mumbai. The charter or the document constituting the company is in Mandarin Chinese language it is. It is required in relation to file a certified translation to the above documents with the Registrar of Companies in India, who can authenticate the translated charter documents as per the provisions of Companies Act and rules made thereunder governing the foreign companies. In such case, translation is made at Mumbai. Read it. Read the question first. You can't understand the answer, so please, I request every one of you, read the question first properly before we go into the solution. Read out the question properly. Read the question, everyone. Reply, everyone. Have you read the question? Listen. Let me first explain you the concept of this particular question. See here. This question is this particular question, whatever we are doing, this question is on rule number 10 of the foreign company rules. Rule number 10 of foreign company rules. Okay. First, this is based on 385 section also. Which section here? 385. See, I will show you section from the Bare Act. See, fee for registration of documents. Here they used as may be prescribed na rule. This is attached to rule number 10. So this is a 385 linked with rule number 10. So let us try to understand what is this particular question all about. Listen, you may not know, may not, chance is there. So let me first explain this. There is no wrong in learning the concept. So please listen. Whenever you wanted to file a document, okay, filing of document. Whenever you wanted to file any document, the document has to be filed. Companies are of two types: Indian company, foreign company. If it is an Indian company, to whom we should file the document? In case of Indian company, all the documents will be filed with the ROC of the concerned jurisdiction. For example, my company is incorporated in, say for example, my company is incorporated in Hyderabad, Vijayawada, etc. Okay, if it is incorporated in Andhra Pradesh ROC, I should file. Okay. Next, if it is a company incorporated outside India having a place of business in India, this will become a foreign company. Foreign company should file with which ROC? Question will arise or not? Always, wherever that foreign company may establish its place of business. I may have only one place of business, or I may have 40, 50 places of businesses. But where to file? Foreign company should file all its documents with the ROC having jurisdiction at New Delhi. This is one point. Second, whenever the documents are required to be filed by a foreign company with ROC, these documents must be in English language. If it is not in English, a correct translation must be made into English, and then that should be filed with the ROC. So what I said, file in English. If English language, like if the original document is not there, translate it and then file with ROC. But how the translation can be made? Translation ke rule 10 came. There are two types of translation: translation in India, translation outside India. If you wanted to translate outside India, two people can make translation. Number one, who is that? Number one, person having custody of your document. Okay, person having custody of your document. So either this person or notary outside India. Notary outside India. For example, my documents are in Chinese. Okay, the person who is having custody of this document, for example, company memorandum of association is there, Chinese company. That company's memorandum is in Mandarin language. Mandarin is a language in China. Okay, one of the languages widely spoken. In that language, memorandum is there. That person outside India who is having custody, generally company secretary, okay, he has to convert this Chinese document into into English language. Or if you do not know English, then at least a notary will generally have a knowledge for English, so that person has to translate from Chinese to English. Over. If you wanted to translate not outside India but within India, if you wanted to translate, okay, first two problems will come. Document is belonging to India or foreigner, that charter, memorandum, or whatever the case may be, it's a foreign document. It's a foreign document. First thing, foreign document is there. So therefore there are two types of problems. Number one, okay, I'm deleting this. It's a foreign document. Foreign document two problems will come: authenticity problem, translation problem. Means what? First, ROC will go to one person and tell, this person, or company will choose one person within India who is having a knowledge in original as well as in English. Means a person within India who is having a knowledge in both Chinese Mandarin language and English language. To that person we will go. We will get it translated. Once translated, Mandarin language, the Chinese language will now become English. Okay, conversion of language is only made. But what about the legality? That's why a advocate or a attorney in high court, those kind of people will authenticate the validity of the legal validity of the document. Okay, for example, you will give me a stamp paper writing in Chinese language. I have knowledge on Chinese as well as English. Example. Now what I can do, I will read word by word, convert that Chinese language into English. That I can do. I am not an advocate. I know language and Chinese language and English language. What I can do, if you give me, I will convert. But legality aspect, I don't know. So therefore, lawmaker also said the same. One person will check about the translation. Language translation will be done by one person. And after that, whenever language translation is done, legality aspect will be looked after by another person. So that's why what they said, see here in the rule. Where such translation is made within India, it shall be authenticated by advocate, attorney or a pleader of high court, not district court. Advocate, attorney or a pleader. Okay, advocate, attorney or a pleader of what? Of high court. Or next, an affidavit of a competent person having, in the opinion of registrar, adequate knowledge of language of original and of the English. Okay, so this person and this person are eligible to do that. In the instant case, Kingai Holding industrial company can translate the related documents within India and authenticated by the person using the above rules. So translation will be made by one person. After that, legal authentication will be done by a advocate. And again, whether really the translation is made or not properly, you can also take a affidavit from a competent person in the opinion of the registrar. Okay, this is the point for the given question. But in CA Inter, this rule is not there. That's why I'm not going very deep into that. Just if they ask a question by any chance, you should be able to write. Next one. Roni Coleman Limited, a foreign company, failed to deliver some documents to the Registrar of Companies as per Section 380 of the Companies Act. State the provisions of penalty. Just to read the same question. The only thing is imprisonment for a term which may extend to 6 months is now deleted. Remaining everything is same. Next, ABC Limited, a foreign company having Indian principal place of business at Kolkata, West Bengal, is required to deliver certain documents with the register under Companies Act. You are required to state whether the said company should deliver such document. First, it is a foreign company. It is a foreign company. Now the question, where the said company should deliver, not whether the said company should deliver. Okay, is required to deliver where. Just now I said wherever the foreign companies are incorporated in India having places of businesses. You may have your principal place of business in Kolkata, Hyderabad, Chennai, wherever you have, but the answer is same. Okay, the documents must be delivered only to the registrar having jurisdiction at New Delhi. Done. Next, in case a foreign company does not deliver its documents, state the penalty. Same concept again, except one thing, everything is same. Okay, what is that one thing that you need to change? Punishable. Sorry. I'm really sorry. Here, imprisonment I did not include in the book, so no problem. Directly you have to write. Next, DEJY, a company incorporated, a company limited incorporated. DEJY is a company limited incorporated in Singapore, desires to establish a branch office in Mumbai. You are a practicing chartered accountant having been appointed by the company as a liaison officer for the compliance of the legal formalities on behalf of company. Explain the provisions of Companies Act and answer the following. Whether branch office will be considered as a company incorporated outside India. First tell me. This is a company incorporated outside India, that is in Singapore. It wanted to establish a branch office at Mumbai. Okay, branch office at Mumbai. So it wanted to start a branch in India. First we have to write definition of a foreign company. What is a foreign company? Foreign company means a company incorporated outside India, having a place of business in India, either by itself has a branch or through agents like franchises, either physically or electronic mode. Now, Branch office will be considered as, branch means what, you are doing the business through that branch directly itself. Okay. Will it be considered as a foreign company now? Yes, it is a foreign company because it is a company incorporated outside India having a place of business in India through the branch. 1 point over. Next, conducts any business. Branch offices are generally considered as a reflection of the parent company's office. Thus, branch offices of a company incorporated outside India are considered as a place of business for conducting the business activity. So, branch means itself. Franchisee means through agents. Next, if yes, state the documents you are required to furnish on behalf of the company on establishing the branch office in Mumbai. What are all the documents you need to submit? Very, very easy. Listen, this question was repeated 6 7 times in exam. It was there in the book also. So 6 7 times we need not read. I will discuss once. So please follow on properly with this regard. Number one, what are all the documents we need to furnish? What are all the documents we need to furnish? Other question. Listen, there are 7 documents we need to furnish. Which, how many? 7. What documents we need to furnish? Keep it away. So, what is the concept? Let us understand. Company incorporated outside India. Place of business is in India. After establishing place of business, we have to furnish certain documents with ROC. What are all the documents we need to furnish to the ROC after establishing place of business? 7 documents. Number one, charter, statutes, memorandum, articles, and any other document defining the constitution of the company. Okay, means what? In India we call memorandum articles. Otherwise, outside India we can call it in any way. Whatever the source documents of company, charter they call. What is it? Charter documents. Okay, you call it memorandum, you call it article, you call it charter. Charter means the source, main documents of the company. Okay, and any other document defining the constitution of company. All the documents, charter, statute, memorandum, articles, any instrument defining the constitution of a company. First, you need to file this. If they are not in English, translation. Just now we read now, like that you should translate. Very easy point. Full address of place of business, full address of the registered office outside India. Full address of registered office outside India. Okay. Next, full address of the place of business in India. Principal office of the company in India. Registered office outside India, principal place of business office in India. Two things. Next, with regard to the directors and secretary, you need to provide some details. Okay, what details? Just remember the all 11 and 12 you need not read. 6 7 you remember and write down. Names of directors and company secretaries. Names of directors and company secretaries. What details? Personal name, surname, director name along with his surname. Any formal name means what? If he changes his name recently, what is the old name also you have to give? His father name, mother name, and married spouse name. Date of birth, residential address, nationality, passport, PAN number. Okay. If he is a director, the DIN number. If he is a company secretary, the membership number. Membership number, email ID. At least remember 5 to 6. Summarize. 3 points we completed. Technically, I can tell that. See here. These many points are there now. Let's see one by one. First point, what we completed: charter, statute, memorandum, articles, any document defining the constitution of company. Number one. Number two, you have to file the documents relating to. Okay, you have to file the document relating to the full address of the registered office outside India, full address of the place of business within India. Next one, details of directors and secretary. What detail? Name including surname, any formal name, nationality. Okay, now documents you come: passport, PAN, email ID. 7 over, just 6 over. And after that, you need to find date of birth, name of the father, mother, and spouse, if any. That's it. 7 8 points completed. Next, after that, just now I told you one question. First question: whenever you establish a foreign company with a place of business in India, you need not send the documents to RO outside India. One authorized representative will be there who is a individual. He should be Indian resident. To his address you need to serve the notice. Then it will be deemed that you are serving to foreign company. That person's name. The name and address are the names and addresses of one or more persons resident in India authorized to accept on behalf of company the service of any process, notice or communication. Simply name and addresses of authorized representative within India. Next, full address of the office of the company in India. their full address of registered office. Here full address of uh, place of business in India. India la place of businesses are of two types. Place of business, principal place of business. Principal place means head office type. In that place of business, it's like head place of business. All others are other. So principal place of business wherever is located, full address of the principal POB. Next, if this company, foreign company, which is incorporated outside India, once upon a time it established a place of business. There is a company incorporated outside India. Once upon a time it established a place of business in India, came to India, closed it, went back. Again it is coming. So at that time you should tell particulars of opening and closing of a place of business in earlier occasion. Next one. Next one is a safety. What safety? You should give a declaration. You should file a declaration that none of the directors, none of the authorized representative have ever been, means in life, never they should be convicted or debarred from formation of companies. So they should not be involved in any fraud in formation of companies. Okay, either in India or abroad. That's important. India la fraud abroad, anywhere fraud should not be there. Means wherever fraud is there, fraud is a fraud, irrespective of place. India like can do fraud, Australia like can do, anywhere fraud is a fraud. So declaration that none of the directors or authorized representatives are debarred for the fraud that occurred in the formation of companies either in India or abroad. Any other information. Next, so these are all the documents you need to file with the ROC. So summarize. Number one, charter, statutes, memorandum, articles, any instrument defining the constitution of company. Number one. Number two, full address of place of business, full address of registered office outside India, full address of place of business within India. Fourth point, first I have written. Number four, details of opening and closing in any previous occasions. Declaration that none of the directors and authorized representatives are guilty of any kind of fraud in relation to the formation of companies either in India or abroad. Any other matter as may be prescribed. And next one, details of directors and company secretaries, the list. That's it. File all these things with the ROC. If you want, I will write here. You have to file in form number FC1 within 30 days of establishing POB. Changes in this should be filed in FC2 within 30 days of such a change. Okay. FC3 you have to file list of places of businesses. In India I have 45 businesses places. In Hyderabad it is there, Vijayawada it is there, in Tirupati, like that. If you are having place of business, give that. In Tamil Nadu I am having in Chennai, Coimbatore or in Trichy, like that. If you are having place of business in different place, give all the details in FC3. This should be filed along with the financial statement. If you want this additional information, you can copy. Okay. With this we completed this question also. I want a reply from everyone. Understood or not? Next. Galileo Limited is a foreign company in Germany and it has established a place of business in Mumbai. Explain the relevant provisions of Companies Act and rules made thereunder relating to preparation and filing of financial statements. Listen. Whether foreign companies are required to prepare and file the financial statements like an Indian company? And the answer is yes. Section 381 says this. Section 381 of Companies Act says like this. Every foreign company shall in every calendar year first prepare a balance sheet P&L in such a form containing such particulars etc. Simply up to here. Prepare balance sheet and P&L account. And not only just preparing, deliver a copy of the documents with the registrar. But here they use the word as may be prescribed. Means what is their rules? Our rules say number one, number two. Okay, these are the things you need to write down in examination. Whatever is not required for examination, I will clearly tell you. First, we have to write down a foreign company for every calendar year has to prepare a balance sheet and a profit and loss account. Okay. Next, deliver a copy of those documents with the registrar. Okay. What documents it has to file? First, you need to remember that such form What is the form? Schedule 3. Schedule 3. Sir, mine is a foreign company. As it is Schedule 3 application, I can't do. Therefore, as near thereto as possible for each financial year, you should prepare. Okay. So, first prepare P&L account and balance sheet as per Schedule 3 or as near as possible to Schedule 3. Number 1. Including other documents annexed to be annexed or attached under accounts of company chapter. Sir, what are the documents required to be annexed or attached under accounts of company chapter? Under accounts of company chapter, chapter number 9, you have to annex or attach so many documents: board report, auditor report, cash flow statement, consolidation, anything is there, all those things you have to attach. Okay. Not only that, documents relating to the copies of latest consolidated financial statements of the parent company as submitted by it to the prescribed authority in the country of its incorporation. For example, your company is incorporated outside India. Outside India, that company has subsidiaries. Okay, that company which is outside India, to their authorities like MCA in India, they might have filed CFS or not. That also you should attach, such that Indian authorities will know how much revenue this company is getting within India and outside India. Okay. So exam question came, accounts of company, what to write? Number 1, every foreign company shall prepare its financial statements through being P&L account and balance sheet for every financial year and deliver a copy with ROC. Number 1, and it should be in form number Schedule 3 or as near as possible to Schedule 3. Number 2, next, any documents containing any documents which are required to be annexed or attached under chapter 9 should be attached. Next, after that, any consolidated financial statement prepared by the parent foreign company and delivered to the authority outside India, those also should be filed with our ROC. Understood? Next, this point not required for exam. If any of those documents are not in English language, you have to translate. Translation is required. Next, all these documents must be, okay, every foreign company shall send to the registrar along with those documents required to be delivered a copy of a list of all places of business. Just now I said along with the financial statement you have to send, that is in form number FC3. So instead of writing this full point in simple line, how to write an exam? Every company shall file along with the financial statements form number FC3 containing the list of all the places of businesses in India. Okay, along with the balance sheet. That's it. Next, along with that you have to file 3 special statements. Okay, in a foreign company has to file with the ROC 3 special statements. What are those? Statement of related party transaction, statement of repatriation of profits, statement of transfer of funds. What is the difference? Related parties means, any related party transaction done by, okay, done by the foreign company, that means the place of business with these related parties, if there is any, you have to mention that. Second one, okay, how much profit is made by Indian branches? POB is there na, KFC is there, it's having so many business places in India. They are making profit or not? How much profit is taken back to USA? That's called as a repatriation of profits. Okay, how much funding is done by parent company to its POB in India? That's called as a transfer of fund. Okay, all these things we need to understand, and all these things should be delivered to the ROC within a period of 6 months of the close of financial year. Financial year of foreign company. Foreign company may use a different financial year. Na? From the end of that financial year, within 6 months, you have to file these documents with the ROC. 6 months, not 60 days. Okay. So to sum up everything, as per section 381, every foreign company must prepare a P&L and balance sheet as per Schedule 3 or as near as possible to Schedule 3. Number 2, annex or attach all the documents required under Chapter 9. If consolidated financial statements are prepared by a foreign company, parent foreign company, and delivered outside India, those also should be attached to that. Number 4, list of all the places of business you need to file in form number FC3 attached to the financials. Number 5, if this particular foreign company is there and it has to file, this point I am talking about, 3 special statements you need to file: statement of related party transaction, statement of repatriation of profit, statement of transfer of funds. 6th point, all these documents must be filed with the ROC within a period of 6 months from the close of the financial year of the foreign company in form FC4. If you want, you can write. That's it. Next, From here, all are repeated questions only. Fast, we have to complete all the questions and complete. See, in the light of the provisions of Companies Act, examine whether the following companies can be treated as a foreign company. Redstone Limited is a company registered in Singapore. Board of Director meets and execute business decision at their board meeting held in India. Very litigant question. Read the question properly before we go into the next part. See, Redstone Limited is a company registered in Singapore. Board of Directors meets and executes business decisions at their board meeting held in India. Read. Lesson. What is the foreign company? Foreign company means a company or a body corporate incorporated outside India having a place of business in India. Place of business and conducts a business in any other manner. Okay. Here what is only conducted? Board meetings are conducted in India. First you have to write about the provisions. Okay. In the given situation, Redstone Limited is registered in Singapore. However, it does not have any place of business, whether by itself or through agent or electronic mode, and does not conduct any. Mere holding a board meeting and executing business decision cannot be termed as conducting business. So it is not a foreign company in the first case. Okay. Actually, study material, Institute Answer, they have given electronic mode. Okay. Why they have given electronic mode? They did not give electronic mode answer. The list of all electronic business to customer, the 5 points. They did not write for point 1. They have written for point 2. Zen Limited, Zen Limited company registered in Dubai has installed a main server in Dubai for maintaining office automation software by cloud computing for its client in India. Cloud computing is a electronic mode. It will be treated as electronic because we have a list. In that list cloud computing also came. Sir, business to customer, business to consumer, business to customer or consumer anything, and business to business, web based marketing, data interchange. After that advisory services and web based services. After that cloud computing also came. Cloud computing is a electronic mode of doing a place of business, but main server location is relevant or not relevant. Server may be either in India, server may be outside India. Are you providing cloud computing services to the clients in India or not? Yes, that regarded as a place of business. That's why. See here. Email, mobile devices, cloud computing, etc. In the given situation, Zen Limited is a registered in Dubai, installed main server in Dubai for maintaining office. Thus, it can be said that Zen Limited has a place of business in India through electronic mode. Hence, Zen Limited liability company is a foreign company. So, place of server is irrelevant. Already I told you that. Next. Abroad Limited. Which one? Abroad Limited, a foreign company, without establishing a place of business in India, proposes to issue prospectus. Sir, all prospectus related I will discuss in one set. Okay. Any prospectus related question I will discuss in one set, not now. So because all prospectus related question has a common answer, so we will discuss once only, not now. Okay. Next, let us start with the next question. Question number 30. Jackson and Jackson LLC, Limited Liability Company, incorporated in Germany, is proposing to establish a business in Mumbai. Its official documents are in German language. Whether Jackson and Jackson can file the required documents with registered in the same language? No. Whenever you wanted to file a document, okay, you have to file in English. If the documents are not in English, certified translation you have to do. That's it. Next. Search and Find Pte Limited, incorporated in Singapore. The company sells its goods through the electronic mode on e-commerce platform. However, it does not have any branch office in India. Okay. Is the company required to submit the documents under section 380? 380 lo who is required to submit documents? Foreign company who established a place of business in India. Okay, first it is incorporated in Singapore. So company incorporated outside India. E-commerce, if you do electronic mode or not an electronic mode, place of business can be done either physically or in electronic mode. In that electronic mode, e-commerce will come or not? Yes. Place of business in India is also satisfied. It is a foreign company. Yes, it is required to file documents under 380. So, and required to submit documents under 380. Next, first you have to write the definition, later conclusion. Next, examine with reference to the provisions of Companies Act 2013 whether the following companies can be treated as a foreign company. Company incorporated outside India having share registration. Yes, required. Company incorporated in Singapore for the purpose of carrying on business. Indian citizens incorporated a company in Singapore. Okay, see, company incorporated in Singapore. Shareholders are Indians. For the purpose of carrying on business there. It's a place of business in India. No. Indian citizens being shareholders don't make Indian company. Neither a foreign company also. Same question. Therefore, company incorporated outside India having share registration office is treated as a foreign company. In case company incorporated in Singapore for the purpose of carrying on business, it will not fall into the definition. Next. X incorporated a foreign company registered in UK and carrying on trading activity with the principal place of business in Chennai. Company did not obtain registration or file. Same question again. MTP 2 marks of question came na. Same question already we completed it. Share transfer office over. Company is XYZ Limited, London. Share transfer office at Mumbai. Same that was exam when the mock test question again they asked. Okay, RTP also. ABC Limited, a foreign company having its Indian place of business in Kolkata, West Bengal, is required to deliver documents to registrar under the provisions. You are required to state where the said company. Already we discussed ROC of New Delhi. Next, Abroad Limited. Again, this question also we completed just now. Okay. Abroad, no, not completed. It's related to prospectus. We will discuss separately. I said. Next, Radix Limited. Oh, more 8 marks question. ரொம்ப பெரிய question. Let's read. Radix Limited is a company registered in Thailand. Although it has no place of business, it engaged in online business through the remote delivery of healthcare, telemedicine. State the legal provision as to the nature. First, you have to write foreign company definition. Elaborate the electronic mode 5 points. Lastly, conclusion will be treated as a foreign company. Telemedicine. Answer over. That's it. Next. Delegate Limited, incorporated in Singapore, decides to establish a place of business at Mumbai. You are required, you being a practicing chartered accountant, have been appointed by the company as a liaison officer for complaint. 380. Just now we read now all the details. Everything you need to file. Done. Next. Next. Again, MTP 8 marks question. Let's see. Z Limited, a foreign company incorporated in Japan, has a branch office in Hyderabad in India. Mr. Bhartiya, the Indian citizen, holds preference shares of Z Limited, which comprises of 10% of the paid up share capital of the company. Deshi Limited, a company incorporated in India, holds equity shares of Z Limited, which comprises 45% of the paid up share capital of the company. During the financial year 1920, there has been alteration in the particulars of document mentioned in 380 of the Act. The company has failed to submit the alterations to the registrar within 30 days. Analyze in the light of applicable laws the consequences of failure of the validity of contracts entered into by the foreign company. Read the question first. Read the question before we go into solution. Read the question first. Have you read the question, everyone? Have you read the question? So enough time given for you to read the question in this case. Reply, everyone. Have you read the question? Yeah. Why I asked you to read this question is it's a multi type of question where they tested so many points inside this. First one, understand there is a foreign company incorporating Japan. Okay. Has a branch office in Hyderabad. Company incorporated outside India and branch in India. It's a foreign company, no doubt. In that company, Indian citizen hold a preferential. Why all this information was given? There is a section called as section 379. Section number 379. That section says like this. There is a foreign company. In this foreign company, okay, in this foreign company, where not less than 50% of the paid up share capital, where not less than 50% of the paid up share capital, whether equity or preference, partly equity or partly preference of a foreign company is held by one or more citizens of India, okay, or one or more company or body corporate incorporated in India, or one or more citizens of India and one or more company or body corporate incorporated in India, whether single or in aggregate. Such company, such foreign company shall comply with provisions of this chapter and other provisions of this act as if it is a Indian company. As if it is a Indian company. Let us understand. Where not less than 50% of the paid up share capital. Which paid up share capital? Either equity or preference or partly equity or partly preference of a foreign company. So 50% of the paid up share capital, whether in the form of equity, preference or combination, is held by Indian citizens or Indian companies or combination, either individually or together. That 50 should be satisfied. Okay, one person need not hold that entire 50. Combination they can hold, whether single or in aggregate. Such a kind of foreign company shall comply with the provisions of this chapter. Shall comply with the provisions of this chapter. What do you mean provisions of this chapter? Foreign company chapter, it has to comply. And other provisions of this act also, as if like an Indian company, because substantial 50% of the capital is held by Indians only. Other logic that they wanted to convey. See here now. See here. Z Limited, a foreign company in which 10% is held by, okay, Indian citizen holds preference shares of Z Limited comprises of 10%. And Deshi Limited, a company incorporated in India, hold equity shares comprises of 45%. So Indian citizen is holding 10% in preference and 45% is held by Indian company. Such company has made alteration to the particulars. I told na FC1 you have to file the original documents under 380. Alteration must be filed in form FC2 within 30 days. But this company failed to submit. Okay. He is asking explain the consequences of failure on the validity of any contracts entered into by foreign company. For this 393 section will apply. For this 379 will apply. Let's see. First 379. Where not less than 50% of the paid up share capital. Just now I said in a chapter, whether equity or preference or partly equity, partly preference of foreign companies held by one or more citizens of India, one or more companies or body corporate incorporated in India, or by one or more citizens and one or more companies or body corporate, single or aggregate, they have to comply with the provisions of this chapter and other provisions of this act as if it were a Indian company. As it is, what I said is there. First you have to write this. Okay, first you have to write this. Next. So amendment also same provision. Amendment just said that section 380 to 386, 300 shall apply to all foreign companies. That's what they said. Okay. So now listen carefully. Main point you have to understand is 393. First you have to write about 379. Okay, actually this is amended provision. Amendment another one point was added that is anyway not relevant for this question. Okay, so this is not required for you. Just if you want in exam, after writing this, you just write down that provisions of section 380 and 386, 392 and 393 shall apply to all the foreign companies. Just write down that and leave. And that has nothing to do with this question now. As per section number 393, let me explain what is 393. 393 section says that if any foreign company failed to comply with the provisions, means filing has to be done under 380. Whenever there is a change in the particulars already filed, you have to file form FC2 within 30 days. You did not file. It's a failure. Penalty will be levied. Or the punishment already is there. Fine, minimum 50,000, maximum 5 lakh. On officers in default 25,000, 1 lakh. Like that they said, nah. Along with that, there is another punishment on foreign company. Do you know what is it? The simple punishment that they give, which is a harsh punishment as well. You will be taken out from so many privileges of a company. Generally, company enjoys a feature called as capacity to sue, capacity to be sued. Means I can sue others, others can sue me. Okay, when foreign company do not comply, capacity to sue others will be lost, others can sue you. Okay, means what? Means this foreign company cannot file a case on other, cannot claim a set off, cannot make a counter claim. Set off means I have to give you 1 lakh, you have to give me 2 lakh, or I have to give you 1 lakh, you have to give me 75,000. Okay, set off what will happen? I have to pay only 25,000 to you. That set off also you cannot do if you fail to comply. That's punishment. Monetary punishment, fine is different. This is technical punishment a foreign company has to suffer if they fail to comply with the provisions. So if a foreign company fails to comply with the provisions of this act, what will happen? Capacity to sue will be gone. Capacity to be sued, others can sue you, others can beat you, you can't beat them. Okay, others can slap on our face, but we can't slap them. That's a problem. First, any failure by a company to comply with the provisions shall not affect the validity of any contract, dealing, or a transaction entered into by company or its liability to be sued. Okay, already if any contract is entered, contracts will not be affected. Means a third party will not be affected because of the mistake of foreign company of not filing the document. If you do not file a document, why third party has to suffer? Therefore contracts will get affected or not affected. Shall not affect the validity of a contract. Okay, next, shall not affect liability to be sued. To sue gone, to be sued will be there, it will not get affected. The company shall not be entitled to bring any suit. You can't file a case, you can't claim a set off, you can't make a counter claim. If they make a claim now, you can't counter them, you can't file any legal proceeding also. Are you understanding or not? Until the company has complied with the provisions. That's it. Simple answer. But mark it important for J25. So in an easy way, how can you tell? It will lose its capacity to sue, but capacity to be sued will not get affected. So what is not affected? Contract validity not affected, capacity to be sued not affected. What is affected? You cannot file a suit, you cannot file a legal proceeding, you cannot make a claim set off, you cannot make a counter claim until you comply with the provisions of this chapter. Okay, so in the previous case what we said, equity capital 45% held, preference 10% held, both together 55%. 55%. Okay, 380 section will apply. That's it, that's the conclusion you need to do. Next, X, a foreign company with a place of business in India. X, a foreign company with the place of business in India, ceases to carry on the business in India. State the legal. Already we read now section 376. You will close that company not under winding up under chapter 2021 as an unregistered company you will wind up. Unregistered company. Next, identify which among the following companies can be categorized as a foreign company. Incorporated in Malaysia, registered in Malaysia. Additional condition, developed patients database for a hospital in India, server is in Malaysia. Okay, when you are maintaining a telemedicine or other data, electronic data, if you are maintaining electronic data interchange, electronic data maintenance is done in India, it will be treated as a place of business. Server location is irrelevant. First you have to write the provision. What you have to write in exam first? First write down what is a foreign company. Next elaborate full all 5 points of electronic mode. After that you write down. Malaysia developed patient database. Okay. So though incorporated outside India, it is involving in transactions in India through electronic. Hence, it is a foreign company. Why it is a foreign company? It will come under electronic database in India. Database maintenance in India will also become a place of business. Server is irrelevant. Dubai, no place of business in India, but employs agents in India. No place of business, na? It will first establish a place of business, then appoint agents. That's a place of business. Okay, appointing agent will not become place of business. Okay, so second, not a foreign company, no place of business. Remaining, you can fill the answers na. California, board meetings held in India. No, board meetings will not decide. No business activity. Next, Australia, 15% shareholding held by Indian company. Company incorporated outside India. Place of business in India. 58% shareholding is held by Indian company. Listen, previous section of what we read, foreign company, it should be first. It should be foreign company means it is a company incorporated outside India, having a place of business in India. Then if more than 50% is held by Indian people, Indian Companies Act also will apply to them. Here, company incorporated in Australia, registered in Australia, just 15% shareholding, that will not become foreign company because place of business is not there. Not a foreign company. Next, Washington offers deposits. We read place of business deposits. Electronic mode you are accepting. Yes, it's a foreign company. Hence it. What he has. This is one of the ways of transacting business through electronic modes. However, this company does not have a place of business. No. This answer can be written in a different way. See here, what they have said is offers and invites deposits from the citizens in India. Electronic mode you are doing it. Okay, the doing it itself is a place of business. What institute has assumed in the answer, what they said is first establish a place of business, then accept deposits. Accepting the deposits must require some place in India or not, either electronically or physically. That itself is a place of business. But assumption of what institute has taken is it's not electronic acceptance of deposits, physical acceptance of deposits. Without a place of business, they are doing. How can without a place of business? Institute answer is it's not a foreign company. But actually, this will also become a foreign company because electronically they are accepting offers and deposits. If you can assume that answer, yes, electronic mode is a place of business. Next, Germany, 49% of the shareholding is held by Indian company. Same answer. It is not a foreign company. 49%. Provided, see here, Germany, 49% of shareholding held by Indian company. Okay, two assumptions. Assumption number one, place of business is there. Means automatically foreign company, 49% shareholding by Indian company is there. But here you see how the answer was given. As per provisions, if not less than 50% of shareholding of a foreign company is held by Indian company, it is treated as an Indian company. Here, 49% is held by Indian company. Hence, this is a foreign company only, provided, you have to write an assumption, provided it has a place of business in India. They did not mention anything there about place of business. So, two answers will come also for this. If you assume that place of business is there in India, then it is a foreign company. If not, it is not an Indian company, it's not even a foreign company. Next. By the way, everyone understood the point clearly or not? The controversial point also addressed. How to write in exam, two answers. Everyone understood clearly? Next. A company incorporated in France with limited liability established an office in Baroda and started conducting business activity from its place of business. So, company incorporated in France established an office in Baroda, limited liability. Why they gave? I will tell you. And started conducting business activity in its place of business. In compliance of section 382 of Companies Act, it has conspicuously and clearly exhibited a name board outside its office with the name of the company in English in big block letters. In 3 days, the company received a notice from the registrar stating that it had not properly complied with the requirements of 382. Mention the area of lapses of foreign company which would be mentioned in the notice. Okay, very good question. Okay, let's see. Read the question first. Later we can go with the solution. Read the question, please. Everyone, read the question first. Read the question? Everyone, have you read the question? Have you read the question, everyone? So what is this section all about? Let me explain. There is a section called as 382 in Companies Act. That section says that section 382 section says that whenever there is a foreign company outside the place of business, okay, not only just in the outside the place of business, what to display, where to display, and how to display. Three things are there. Mode of display. What to display? Display, see here. I will explain in a simple way. As per section number 382 of Companies Act, three questions have to be answered. What to display, where to display, mode of display. What to display? Display two things. Very, very important two things what we need to disclose is, first one, where it is? Name of the company, country of its incorporation. One answer over. Along with that, liability of the members. That's why limited liability they gave in the question. So what to display? Name of the company, country of its incorporation, liability of the members. If it is limited, mention that it is limited. Okay, three things. Understood. Next, where to display? It should be displayed in two places. One, outside every place of business. In India, POBs are there, branches. There you have to put a board or you have to paint it and mention conspicuously, clearly. Exhibit on the outside of every place of business. Not only that, and it should be in legible letters in English characters and also in the language used in that locality generally. Okay, that's called as where to display. Where to display? Display outside every place of business where it carries on the business, and also in every prospectus issued. In prospectus, business letters, bill heads, invoices, letter papers, any official publication, wherever the document is there, you need to mention the name of the company, country of its incorporation, and if the liability of the members is limited, that fact that it is limited. Okay, see. So, business letters, bill heads, letter papers, advertisements, official publication. Okay, and outside the place of business, everything. So, what to display? Now, summarize everything. What to display? Display the name of company, country of its incorporation. If the liability of the members is limited, the fact that it is limited. Next, where to display? Outside every place of business and outside every place of business and in every prospectus, bill heads, letter papers, official publications, everything, advertisements. Number three, mode, how it should be conspicuously exhibited in a legible English characters and in English language and in the language of that locality. Next, here ROC sent a notice to that particular company saying that there are some mistakes. What mistakes it has done? See. Company incorporated in France established an office in Baroda starting its activity. It's a foreign company. It conspicuously exhibited a name board outside its office with the name of company in English in a big block letters. Name of company only given. Country of incorporation and liability they did not mention clearly. So, the company exhibited name of company, but it has not displayed the country. Further, it has not displayed in the local languages. English they have mentioned. It should be in English as well as in the language of the locality. Further, if liability is limited, the fact that it is limited has not been consequent. Three mistakes they have done. Okay, what is the mistake number one? Country of incorporation they did not mention. They did not mention the local language. And number three, they did not mention the liability of the members. Next. Up to here, everyone had a clarity? Sir, everyone in the class, please tell me, have you understood clearly up to here? Reply, please, everyone. Okay. Next question. See there. Elegant Educations Limited is a UK based company engaged in the business of providing online education. Remember, online education provided is a electronic mode. It has introduced some certificate courses having a duration of 4 to 6 months, and any person can enroll in the course. Education is provided through the online classes. Webinars and study materials are supplied through emails. Through emails also, if you do anything, supply of any information, electronic mode. The company is not having any place of business in India. It is mentioned that all candidates have enrolled in the course are Indian citizens residing in India. Having not having any place of business. Actually, when you start a business in India, that itself will be treated as an electronic mode of place of business. Based on above facts of procuring 100% of business from India, whether the company will be treated as a foreign company or an Indian company. What will be your answer in the above question if more than 55% of that foreign company paid up share capital is held by Indian company or Indian citizens? First situation number one, you have to write about foreign company definition. After that, you have to write about the electronic mode. Write about electronic mode. Next, 379 section, just now we read now that you have to write because two sections they referred, not less than 50%, all these things. That's it. Okay. Now listen carefully to the point. First point number one. Where is it? Yes. Doing its certificate courses within India. Okay. Place of business is not established. They said physical place of business not required. They are doing online business in India. Okay. Whenever foreign company is considered, foreign company means a company incorporated outside India having a place of business in India, whether by itself or through agents, whether physically or in electronic mode. That place of business is done by itself in electronic mode. Doing in electronic mode itself is a place of business here. So therefore separately they need not establish any place of business. Since 100% of the business is coming within India, it will be treated as a place of business because online education, providing information through emails, both are treated as electronic mode. Okay. Electronic mode means carrying out electronically based, whether main service is installed, but not limited to online services such as telemarketing, telemedicine, education. Tele-education is also included. Online education. Thus, from the above provisions, the company is treated as a foreign company. Whether business 100% are not relevant. It is irrespective of the fact that 100% business comes from India. It is a foreign company. Next one. If 55% of the capital is held by foreign, it is a foreign company where not less than 50% of the paid up share capital, whether equity or preference or partly equity or partly preference of a foreign company is held by one or more citizens of India, one or more companies or body corporate in India, or one or more citizens and one or more body corporate, whether single or in aggregate, such company shall be treated like a Indian company. So, thus in the given case, if more than 50% is held by Indian company, it shall be treated as a company incorporated in India, such that it has to comply with all provisions. Next. Search and find PTE incorporated in Singapore. The company sells its goods through electronic mode in e-commerce. Already we read this. Arika is a company limited incorporated in Singapore, desires to establish a branch office in Mumbai. Liaison officer, legal counsel, all this already we completed 380 section. See, full point we have to write. So let's revise what is there in 380. Charter statutes and any other charter statutes, memorandum articles and any other instrument defining the constitution of a company. Full address of the registrar office outside India. Full address of the principal place of business in India. After that, details of opening and closing of the place of business in any earlier occasions. Okay. Declaration that none of the directors and authorized representative are guilty of any misconduct while informing the company. And names and address or names and addresses of their persons within India who are residents who are authorized to accept the communication on behalf of foreign company, and some details of personal details regarding directors and company secretary, name, surname, all these things. That's it. And you have to file all these within 30 days of establishing place of business in form number FC1. Changes in FC2 within 30 days. List of place of business along with financial statements in FC3. Answer over. Next. LMP Paper is a company registered in Thailand. Though they are not having any place of business, yet doing online business through telemarketing. Yes, this question also we completed. This is also related to 380. Next. Same question, whatever we write. Company incorporated outside India, employs agents in India but has no place of business. Agent appointment is not important. Place of business through agents is important, not a foreign company. Company incorporated outside India having shareholders who are all Indians. Already we completed this question. Same question they asked again. I also kept that. Next, RTP number 21. Fukushima Motors Limited was incorporated in Japan. Its share capital is held by following persons: citizens of India 10, Indian companies 40. The company has opened its representative office in Mumbai on 15 January 2021 in order to receive orders from Indian market and make available the delivery of Japanese luxury cars in Indian purchase to the Indian purchaser. Company was not aware of Indian company law, hence could not file the required documents. The company the company could file all required documents only on 28th of February. 28th of February. Based on the above facts, answer the following. Whether the provisions of Chapter 22 of the Companies Act, means foreign company chapter, are applicable to Tsukushima Motors Limited. What documents are required to be filed by the company to the registrar? By what time all requisite documents shall be filed? Mark it important, J25 key. With change in names they can ask, or directly also question may come in exam. Let's see. What is it? Listen. First thing, whether provisions of Chapter 22 of the Companies Act are applicable or not, let us understand. Point number one, where not less than 50. First, what you have to write here? What you have to write? First, write the foreign company definition. Company incorporated outside India, place of business in India, whether by itself, everything you have to write. 1 month they will give. Since this company is incorporated in Japan and opened an office to take orders, it's a foreign company. Next, as per section 379, not less than 50% of the paid up share capital, whether equity, preference, partly equity, all those things, it will be treated as an Indian company and it has to comply with all the provisions of this act. Okay. Next, it has to file the required documents with the ROC under 380 or not. Okay. Company is not aware of company law. Hence, it could not file the document. If it could not file the document, what will happen? Penalties will be applied. Whether provisions of Chapter 22 are applicable or not? Yes. First question ki direct answer, let us see. Okay. In the given question, company had established representative office on 15, required to file as on 14 to with the registrar. So if it did not file, it will be a punishment. In terms of section 381, every foreign company shall file within 30 days. All these things already we read that. So what are all the documents required? Required documents. What is the time limit to file all the required document? Within 30 days of establishing. So within 30 days means from 15/1, 30 days will become 14/2. That's it. Answer is over. Next. Question number 30. Blue Star Incorporated is a company incorporated in USA 4 years back and has no established place of business in India. Company has entered into a following contracts. Particulars: financial year 17, 18, 18, 19, 19, 20, 20, 21. Particulars: contracts entered, material contracts. Next, apart from the above, one contract has been entered into with its manager. Okay, with its manager. The company intended to offer its securities in India. For that purpose, the secretary of the company, Mr. Berry Kristen, prepared the prospectus along with annexing the required documents and got it registered. Expert consent was issued. I will do one thing. This is also related to prospectus. I told them one question already we saw. Prospectus related. I did not discuss. This is also relating to prospectus. Prospectus I have to discuss separately. That's why. A good question, yeah. Zell Power LLC is a foreign company as per the definition provided in the Companies Act, carrying on the business in India also. It is strictly observing the provisions stated for the current companies in Companies Act, while the registrar is of opinion that ZPL, apart from observing the provision prescribed by the foreign companies, ZPL also need to observe other provisions of Companies Act. That means they are saying that this is not just a foreign company, this is an Indian company. Who is saying? Zell Power Limited, ZPL, is a foreign company as per the definition. It is strictly observing the provisions of foreign company. Normal, this chapter 22, chapter 22 details they are following. Okay. And the ROC is saying that it should not just comply with this chapter, it should comply with other provisions also, like an Indian company, they said. Why? Reason is, ordinary shares, 6 million share, okay, 6 million at rate, face value of pound 5 and 2 paid up. 2 paid up. 6 million, 5 pounds, 2 paid up. What is relevant? Face value is not relevant. Where not less than 50% of the paid up share capital. Paid up is important. 6 million into 2. Okay. It becomes 12 million. Next, 12 million preference shares. Okay, 12 million preference shares. Preference stock. Pound 12 million. It's a value. 1.2 million 1.2 million. It's fully paid. 12 million. Debt fund not required. Mr. Trishi, who is an Indian citizen and residing in India, being a part of promoter group, owns 29 lakh 32,780, means 2.93278 million ordinary shares. Okay, technically 2.932780, okay, with the millions into how much is paid up with regard to what shares? Ordinary shares, means equity shares. How much paid up? 2. So you multiply. Let me calculate. 2.932780 into 2. It is a 5.86556. 5.86556. Okay. Total 12 million. This is 5.86556. Mr. Nirav, who is an Indian citizen, owns 1,09,205 preference stock, means 1.09205 million. Sorry, no, sorry, 0.109205. It's lakh na. So into 10. 0.109205 into 10. 1.09205. Okay. Now what they say, if it is more than total paid up share capital, what is the paid up share capital here? 24 million is the total paid up share capital. Okay. In that, if you hold not less than 50%, Modern Engineering Limited, an Indian company, owns 67,000 ordinary shares, 1,42,320 preference stocks. Okay, Raj Investment Limited, Indian company, is holding these many preference shares. Like that, you have to multiply all. Finally, I have given the answer here. Out of the paid up share capital of pounds 24 million, okay, 12.45 million are held by citizens of India, along with the companies incorporated in India in aggregate. Okay, so 12.45 million means it is more than half or not. That's it. 24 half is 12 million. Okay, now we are holding 12.45. Like this, you need to add everything, whatever I have added now. After adding all these things, it should come to more than one half. So if you want calculations, now this is one calculation. Trishi, who is an Indian citizen and residing in India, holds 29 lakh 32,780, means 2.932 million. Okay, into how much is paid up? 2 rupees is paid up here. So multiply. So 5.86556, and he is holding 1 lakh 9,205. It becomes 1.09205. Modern Engineering Limited, Indian company, holds 67,220. Okay, 67,220. In ordinary, in the ordinary shares, so 2 rupees paid up. It comes to 0.13444. Next, 1,42,320 preference stocks. 142,320 preference stock. Okay, 1,42,320 preference stock into 10 rupees each. So the 10 rupees will come to 1.4232. And finally, others are holding 3,93,000. 3.93475. Like this, you should go on adding 5.86556 plus 1.09205 plus 0.13444 plus 1.4232 plus 3.93475. See, 12.45 exact answer came. So that's what he has given here, 12.45 million. since 24 or 12.45 Indian citizens, Indian companies are holding, this will be treated as an Indian company. Comply not only with the chapter 22, all other provisions of Companies Act also should be complied with. Everyone answer, yeah? Understood the question or not? Such a big question, just like that we can answer. Everyone answer. Reply everyone who are participating. Next. Question number 32. Same, this question already we completed, rule 10. Ronnie Coleman question also we completed, exam question. Okay. Messrs. In the light of above provisions, examine whether following is again same kind of question, yeah, nothing great. Messrs. Redstone Limited is a company registered in Singapore. Board of Directors meets and execute. No, it's not a foreign company. Blue Star is a public company registered in Thailand. Mr. Y in India finds customer and enter into contracts with them on behalf of the company. Okay, see here. Messrs. Blue Star Limited, a public company registered in Thailand, has authorized Mr. Y in India to find customers and enter into contracts. To find customers and enter into contract. Putting a agent itself will not become foreign company. See here, Blue Star Limited registered in Thailand. Okay, Blue Star Limited registered in Thailand. Not just putting authorized person, doing business is important. He is generating the business by putting the customers or not. It has authorized Mr. Y to find customers and to enter into contracts on behalf. Okay, so the point is, the moment customers are grabbed, business is done. Not just putting an agent for namesake, they are also doing business. It has authorized Mr. Y to find customers and enter into contract on behalf of. Thus, it can be said that Mrs. Blue Star Limited has both place of business in India through an agent, okay, and is conducting business activity by grabbing customers. It's a foreign company. Next, not just putting agent and taking customers. Messrs. X Limited, limited liability company registered in Dubai, has installed main servers cloud computing. Yes, you have to write entire answer and then tell that cloud computing comes under the category. See, electronic mode question came 8 times till now. Again in Jan 25, chance is there. Next, again considered as a foreign company or not. A company incorporated outside India, registered in Moscow, Russia, installed main server, okay, maintaining office automation service, yes, cloud computing. Just now we write the answer and then conclude, yes. A company which is incorporated outside India employs agents but has no place, no. Company incorporated outside India, registered in Australia, has authorized representative, yes. Just now we write the same question type, okay. A company incorporated outside India and registered in Mauritius, okay. All the business models, financial strategy, important decisions are carried on and taken at board meetings held only in India. No, just board meetings held will not make a foreign company. Next. So it's not a foreign company, board meetings. Next. Phil Health Systems Incorporated, PHSI, is a foreign company registered in Australia, has established a place of business in India. The financial statements pertaining to Indian business operations for the year ended 2020 were prepared by the company. Referring to the advisor, whether accounts of the company pertaining to Indian business operations shall be audited? Yes. Accounts we read. How to prepare finance statements, schedule 3, attach and annex the documents required under chapter number 9. Remember, it's consolidated financial statement of a parent foreign company filed with its authority. 3 statements: statement of related party transaction, repatriation of funds and transfer of funds. All those things we will file. Audit is required. Yes, audit also is required to be conducted like an Indian company. Means either by an individual or by a firm of chartered accountants, audit has to be conducted. Okay. See, according to the Companies Act rules, it shall get it audited pertaining to Indian business operation by a practicing chartered accountant or a firm. Okay. Next. What is the due date of filing audited financial statement? 6 months from the end of the financial year. 6 months of the close of the financial year of foreign company. Next. What is the effect of contracts entered by in case PH? What is the effect of contract? Contracts will not get affected. Everything in it shall not invalidate the contract. Not it shall invalidate. It shall not invalidate means it will not affect the contract. You have to write section and write the conclusion. Already I discussed about section 393. In which e-form and within which period annual return must be filed. Okay. FC4. FC4. Within 60 days of the financial year. Within 60 days of financial year. Understood? So with this we completed question number 36. Question number 37. Tokyo Ferro Alloys Limited, a company registered in Japan, started its operation in India by establishing a marketing division in Mumbai on 1st April 2021. Recently, the company decided to issue certain securities. This is relating to prospectus. We'll discuss separately. Vibo PTE, a company incorporated in Singapore, is having liaison office in Delhi. Liaison officer seeks your advice regarding documents to be filed with registrar. Section 380. Just now we read all 7 documents. Charter, statutes, memorandum, articles, and any other document defining the constitution of company, principal register office outside India, principal place, all those. Okay. You have to file all the documents with the ROC. Okay, and he is also asking documents to be filed along with financial statement. I'm very sorry, he's not asking documents to be filed for place of business. Along with financial statements, what we need to file, along with the financial statement, any document required to be annexed or attached. After that, consolidated financial statement document, special statement. Okay, all those things you need to file the statement of related party, all these. Next, similar question to the previous one what we have done, but see, RFC Limited has been incorporated in Singapore, has a place of business in Mumbai. The company has issued 5 lakh shares of US dollar 100 each, consisting of 4 lakh equity shares, 1 lakh preference shares. The issued share capital is fully paid up except 5,000 preference shares where 50 US dollar is still unpaid. RJW, an Indian citizen holding 26,000 preference shares, which include 1,100 partly paid shares, and Ronte Limited, incorporated in New Delhi, is holding 2,20,500 equity shares in RFC Limited. The Registrar of Companies issued a notice under 379 addressed to the person whose name is delivered to the ROC by RFC Limited for compliance of Companies Act. The above notice was delivered at the address which was given by RFC Limited to the registrar. Answer the following with reference to the provisions of Companies Act 2013 whether RFC Limited is a foreign company. Serving the notice is valid. Full conceptual question. Read the question properly before we go to the solution. Read the question. So see here. RFC Limited has been incorporated in Singapore and has a business place in Mumbai. The company has issued 5 lakh shares of US dollar 100 each, consisting of 4 lakh equity shares, etc. Like that they have given. So first understand the scenario properly. We require paid up. Okay, we require how much is paid up, that is important for us in calculation. This particular company issued 5 lakh shares of US dollar 100 each. Okay, consisting of 4 lakh equity shares and 1 lakh preference shares. 5 lakh shares lo 4 lakh are equity, 1 lakh are preference. The issued share capital is fully paid up. The issued share capital is fully paid up except 5,000 preference shares, where US dollar 50 per share is unpaid. Means 4 lakh equity shares fully paid, 100 each. And 1 lakh preference shares 95,000 are fully paid, 50,000 are not fully paid. So paid up value is only how much? 50 into 5,000 only you should take, 2,50,000. Next, RJW, an Indian citizen, is holding 26,000 preference shares in which include 1100 partly paid shares. Ante in this 5,000, 1100 are held by RJW, an Indian citizen. Next, Ronti Limited, incorporated in New Delhi, is holding 2,20,000 equity shares in RFC Limited. So first, let us see the calculation work. Point number 1. 4 lakh into 100. 4 lakh into 100. Okay, 4 lakh into 100. 4 crore dollars. And with regard to the preference shares, how many preference shares are there? 1 lakh preference shares are there. 1 lakh. You can't take directly in these two branches. I will do this way. 95,000 into 100. 95,000 into 100. Okay. Dollars. Next, 5,000 into 50. Dollars 2,50,000. Total 9750. The dollars. Okay, next. In this, what he is saying, 4 lakh equity shares are there. In that 4 lakh equity shares, 2,23,500 equity shares are held by RFC Limited, an Indian company. From this, what will happen? Where not less than 50% of the paid up share capital, whether equity or preference or partly equity, partly preference. Here 4 lakh, 2,23,000 is held by them only. So substantial Indian holding is there. This will be considered as a Indian company. So register of company issued a notice under 379. Okay. Whether RFC Limited is a foreign company? Yes, it's a foreign company, but it required to comply with the provisions of Companies Act. First, you have to write foreign company definition. Next to 379 full section you have to write. After that, like this, you need to write down. Here I have written 97 lakh 50,000 to 4 crore. So 4 crore 97 lakh 50,000. Okay. In this, they are holding this way, aggregate shareholding. So now you have to understand, therefore RFC Limited is not only a foreign company, but shall also be complying with the provisions of this chapter, okay, as if it were a company incorporated. It is a foreign company. Along with that, you should also comply with other provisions. Service of notice by ROC is valid or not? Yes, it will be valid. 383 section we read now. Whenever ROC wanted to serve any notice, process or a communication, it shall be deemed to be sufficiently served if addressed to the person whose address and whose name and address have been delivered to ROC under section number 380. Okay. So already we read, any process, notice or other document required to be served on a foreign company shall be deemed to be sufficiently served if addressed to the person whose name is delivered to the ROC. You can send by post or by electronic mode that notice. Next. MNO Limited, a foreign joint venture company, having its established place of business in India and following international financial reporting standards, and its financial statement being prepared in German language, desires to know the following with regard to the submission of financial statement. India we don't follow IFRS. India we follow Ind AS. So Schedule 3 is prepared as per the provisions of Ind AS, not as per IFRS. What I said, whenever accounts are to be filed, you should be prepared as per the Schedule 3 or as near as possible to Schedule 3. Okay. Submission of finance statement German language. No, you cannot submit the finance statements to the ROC in India in German language. You should submit in English language. If not in English, certified translation is mandatory. Format in which financial statements are to be filed. You should file as per Schedule 3. If not possible, as near as possible to Schedule 3, you have to incline and align your financials and file. How authentication should be done? Authentication of financial statement. Normally, only authentication should be done by the board of directors of the company. Whether documents can be submitted at the registry office at Mumbai? No. All the documents should be submitted only to the ROC in New Delhi. So, by the foreign company shall be in English language. If they are not in English, submit in the certified translation. Next, format of the financial statement as per IFRS. It should be as per the Ind AS you have to file. If IFRS it is there, you cannot. But consolidation, if you see here in the question, how format of financial statement as per IFRS. That's it. Following international financial standards, it's in German language. Like that he asked. They did not ask anything about the consolidation, but they have written here. But you should follow Schedule 3 or as near as possible to Schedule 3. Next, authentication of translated financial statement. Just now we said whenever authentication is to be done, authentication should be done by either outside India or within India. If it is authenticated within India, okay, if it is authenticated within India, either by an attorney, all those things. Anyway, this is not applicable for CA Inter. Next, whether the documents can be submitted to Mumbai 2021 CA final question. Their rule 10 also applicable. For CA Inter rule 10 not applicable, just for understanding sake I said. So next, only 1, 2 applicable, third not applicable for CA Inter, fourth. Can be submitted at Mumbai? No. Always ROC means ROC at New Delhi. Okay. Documents cannot be submitted at New Delhi. Okay. Next, only New Delhi, not in Mumbai. Next, last question. CNC Limited is a foreign company having its places of businesses in Mumbai, okay, and Ahmedabad in India. It has amended its Memorandum of Association on 1st June 2022 and closed the branch situated at Mumbai. Referring to the provisions of Companies Act, advise the company. Compliance procedure regarding amendment of memorandum. Compliance procedure as regard to the closure of Mumbai office and discontinuing submission of documents. Okay, first, CNC Limited, a foreign company having its place of business in Mumbai and Ahmedabad. It has amended memorandum on 1st June and closed the branch office at Mumbai. So first point number 1, whenever it makes a memorandum alteration, if you remember, whenever you start a place of business, you need to file documents with ROC. In that, charter, statutes, memorandum, articles you will file. In that, if the changes come, FC2 you should file within 30 days. So 1st June you change and on or before the 30th of that particular month, means latest by 1st July, within 30 days, you have to file the particulars of change within 30 days in form number FC2. First write the provision, then write the conclusion for that point. Next, compliance procedure regarding the closure of Mumbai office. Okay, whenever you wanted to close the Mumbai office, discontinuance if you want to do, if any foreign company ceases to have a place of business, it shall give a notice of fact to the registrar. Okay, once you wanted to close that, how you informed ROC when you started, like that you should also inform ROC when you close. And from the date on which such notice is given, obligation of company to deliver any document will cease. Cease means stop, provided there is no place of business in India. Hence, in the given case, CNC Limited has still Ahmedabad as a place of business in India, so will continue to submit. Even though Mumbai office is closed, it has a place of business also in Ahmedabad or not. You have to still file. So closure of one place of business will not close entire company, entire foreign business, entire Indian business of a foreign company. If all the businesses are closed, and if you inform ROC that you wanted to close the business, that's it. Remaining documents you need not file. I repeat one more time to have a clarity. There is a foreign company, established a place of business in India, in two places, Mumbai, Ahmedabad. Ahmedabad it is still there, Mumbai it is closing. Now it will lead to full closure of business. No, Ahmedabad it will continue, and submission of documents with ROC, filing financials still applicable, because still you are doing business. If you close both of them, immediately inform ROC that you don't have any place of business. The moment you inform and it is received to ROC, from that moment, no other documents a foreign company in India need to file. With this, we completed all the 40 questions in the foreign company chapter. Everyone who joined the live, are you all comfortable with this chapter or not? A 7 marks chapter has been completed in this set. Reply everyone. Everyone, clarity? Clear? So question, one person asked the question, sir, does the same compliance apply for a foreign airline companies having share capital the same as foreign company? Means yes, it will be. Every other person in the class, did you understand the concept clearly? Everyone who joined live, full clarity everyone. Okay. So with this, we are stopping the session. Tomorrow session, we can have much lengthy session. A 3.5 hour session we can have. Now it's almost around 3 hours. So tomorrow we will have another session and we will complete FEMA as well as dividends. Okay, dividends and FEMA are the target. We'll complete them. Thank you very much, everyone. Those who joined live. So with this, we have completed the foreign company chapter. A 6 to 7 marks will come from this chapter. 8 marks also expected because of MCQs. So we have completed all these points and this concept. Next we are going to start with the FEMA. Okay. FEMA will start once after this. FEMA also will come. If already upload in the YouTube channel FEMA, you follow that. Okay. This chapter is completed. Foreign company is over. Okay. Now we started with interpretation of statutes. Now interpretation of statutes is over. After interpretation of statutes is completed, we started with foreign company. Next to FEMA. After that, dividends and other chapters I will. Okay. Thank you very much. All the best.